Um, then, Chair, on fruitless and wasteful expenditure as well as irregular expenditure. Firstly, on irregular expenditure, uh, it would be good to hear what consequence management has been embarked upon. And then I want to say that in terms of the reporting, the annual of the disclosure in the annual report, that in case of 11 matters where the public protector first embarked on I want to say, a litigation or defense of matters, and the then investigation or analysis of the litigation matters in which the public protector is involved in, and 11 matters then where defense have been withdrawn because in what the annual report calls there was minimal chance of success. I would want to argue that this, of course, is talking to few possible future fruitless and wasteful expenditure findings. And I would want to argue that this must be dealt with proactively in this way, along with the 2.1 million rand that has already been identified as fruitless and wasteful expenditure in respect of what is called the secure accommodation in past years, and the year under discussion of the former public protector. And we, of course, know that proper consequence management must be that whoever caused fruitless and wasteful expenditure must then be personally responsible to refund it. And I want to hear what steps have been taken to ensure that. Um, and that is, of course, uh, to be linked with the issue that has not been addressed here, Chair, even though I accept that it strictly speaking is not within the requirement to report on the annual report, but it is out there, and one would have thought that at least when you towards the end indicated whether there's any other issue that needs to be discussed, that the acting public protector would maybe have taken the committee in confidence about the gratuity of the impeached former public protector. Um, Obviously, we have noted that in the public domain and through some press reports, it's clear that this is a hot potato. On the one hand, one would think that it is only logical that any gratuity that somebody who concludes a term of office would be entitled to is forfeited um, if and when impeached before the end of the term. Seemingly, there is a view that because this is not spelled out in great detail in the act itself, that there at some point was a strong consideration of nonetheless making the payment. And then if news reports is to believe, then it was decided that it's not as simple as that. So the question firstly is, what is now the status of the analysis around whether the former public protector is entitled to the gratuity? Has legal opinion been sourced? At some point, seemingly there was a view that Parliament and this committee, as the oversight body, needs to be involved, which might not necessarily be true in taking this decision. But nonetheless, I would think as an oversight body, we're entitled to be briefed on the way the analysis of the situation is unfolding. And then, as I said, closely linked to that must be uh, consequence management, of course, in respect of fruitless and wasteful expenditure caused during the term of office by the former public protector. And then the last question I want to ask, also strictly speaking, of course, not part of the annual report yet, but whether a final calculation has now been made and whether the committee could be briefed on the total expenses incurred by the office in respect of the Section 194 inquiry, that of course being legal costs and fees, travel and accommodation, so that we ultimately can be in a position to also, for future purposes, know what the implications are for the public purse if and when inquiries like this is to be embarked upon. Thank you, Chair.
Thank you very much, Honorable Horn. I was under the impression that there are figures in the annual report about the expenses of the Section 194, including, I think, the 1.2 million on traveling. But I think they will respond when the time comes. Honorable Nivo Tuhan.
Thank you, Chairperson, and good morning to everyone. Thank you to the Public Protector South Africa team for the presentation. I have a few questions. The 17 people who resigned is quite a lot, but I would like to ask a question with regard to that. Those who resigned, if the PPSA has already done the exit interviews and what the reasons in general were for them to resign, if it was mentioned in the exit interviews. Then also I wanted to understand the funded positions. From the funded positions, how many have been filled? Because it's already funded. If it's unfunded, I understand the cost containment issues, nobody is appointed yet, but from the funded positions, how many have already been appointed? And with regard to the CBOs, the community-based organizations that the PPSA briefed or made presentations to, I still want to know. I think I asked this question previously, but I'm going to ask it again for this financial year. The presentations to people with disabilities. Two SMSs I quickly checked this morning from Disabled People South Africa said they've never received a presentation from PPSA, and DEFSA doesn't even know who the PPSA is. So I wanted to ask, during the year under review, if the PPSA has ever made presentations to community-based organizations, including people with disabilities. When you talk on the radio, yes, we appreciate that, but obviously deaf people don't have access to the radio. So I'm wondering whether you have any presentations done on TV with subtitles and sign language interpreters. Then with regard to the equity, I see the number of employment equity in your equity plan of the PPSA, the gender numbers. I see the target for people with disabilities. I think there's only 1 out of 6 that was targeted to be met for a person appointed with disability. Now, I'm just curious for this year under review, what the percentage of disabled people appointed, and if the PPSA has ever worked with any other organization that represents disabled people, where you can advertise for or send advertisements to get people appointed. We have deaf people who are lawyers, who are unemployed, waiting for jobs. It seems nobody in the justice area wants to appoint a deaf person. He studied to become a lawyer, and so that's why I'm asking, which organizations you contact when you do your recruitment for disabled people. Then under irregular expenditure, I see the process for selection of legal services. That process wasn't followed, and that falls under irregular expenditure. I wanted to know what processes was then put in place to make sure that the processes are correctly followed. And the last line, I'm also not clear on the acting PP presentation. On the last line, I see the Department of Public Works phased out free office accommodation. So I just wanted clarity in exactly what that means, and then user charge, that's just a breakdown, or like what exactly do you mean with regard to that sentence? And then I think that is it from my side. Thank you, Chairperson.
Thank you, Honorable Neville Stohan. And then Honorable Breitenbach.
Thank you, Honorable Chair. Good morning to everybody. I'm largely covered with regards to the errors in the report. I would, however, like to know what additional steps have been put in place to make sure that this doesn't reoccur. So has the quality assurance been beefed up, not only with regards to this report, but to reports in general? I'm covered with regards to the acting appointments and the fruitless and wasteful expenditure. I would also like more detail on the what's going to be done to recover the monies of the accommodation of the previous public protector, what steps have been put in place. And then it appears that the public protector failed to submit a required report to the information regulator. Why is this? Has it now been submitted? And why was it not submitted? And then, Chair, there's been a decline in finalization of matters year on year. So I'd like to know what steps are being taken to improve that. And why has this decline not been arrested? Thank you, Chair.
Thank you, Honorable Breitenbach. Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, we are very impressed with the report submitted by the Public Protector, especially the audit findings. We know that she was acting for half the year, so we have to congratulate the previous Public Protector and this Public Protector for this particular presentation. Chair, the important issue is the funding. And I think that there needs to be more creativity. I don't know if the Constitution or the rules of the Public Protector's Office allows this, but certainly, Chair, organizations on the JSE like Absa Bank and Naspers and mining companies, they shouldn't come to the Public Protector for a cheap hearing or a cheap legal process. They must go directly to the High Court. So we have a situation where many of these organizations who are cash flat, who've got so much cash, they try and save a buck or two. Shouldn't there be procedures in place that a cutoff point that, if you are below a certain amount, then you can approach the Public Protector. Also, just too much money is being spent on legal costs when matters are taken to the High Court by these same companies. We are obviously concerned that nearly 1/3 of positions are not filled. So the Public Protector's Office is doing a 2/3 job, and we want them to do a 100% job, but they don't have the staff. I'm just worried that maybe, we don't need an Office of the Public Protector, that work must be done by a specialist court in terms of the Superior Courts Act. After we have seen what has happened with the impeachment of the other Public Protector and the matters before us and the high standards was imposed. Now, I'm prejudiced, Honorable Chair, because I've worked for 30 years doing cases in the CCMA, and there you have a speedy resolution process, and the CCMA doesn't have the same onerous issues of having to go to the High Court to defend its decisions. So I would like to hear from the public protector if there are any ideas with regard to limiting, especially JSE companies, from using her offices. There are many other important cases that are now that stands in the queue of ordinary people, issues relating to service delivery, issues relating to sewage pollution, and so on, which the public protector should also address. Thank you very much, Honorable Chair.
Thank you very much, Honorable Hendricks. Public Protector.
Thank you, Honorable Chair and Honorable Members, for those questions. I will then leave to CEO and the team to answer the questions, and should there be any further clarity that I need to provide, I shall do so. Thank you. CEO.
Thank you, Acting PP. Thank you, Honorable Chair, and we really appreciate the questions from the members. I will start with the vacancy rate. I think when Acting PP made a presentation, she mentioned that we have filled all the senior management positions. The COO position, the CFO position, and the executive manager positions. All the senior management positions have been filled. The only vacant positions at senior management level now are the positions that were vacated recently. The Chief of Staff, as well as the Senior Manager Executive Support in the Office of the Public Protector. Those are the only two. So the rest of the people are normally the people below the senior management level, and those are the people who are highly mobile, for lack of a better way, because those people are still young and they are qualified, so they come to the Public Protector and then they find other opportunities. Because when we do exit interviews with them, they always indicate that they have found a better offer elsewhere in another institution because of their qualifications, because of their age. They are highly marketable, so they are able to move and get other positions elsewhere. So that's what they tell us during the exit interviews. But just to emphasize that we have filled all the senior management positions besides the two that were vacated recently. And I must say, probably last time we presented, yes, when we presented the APP, we had just appointed the executive manager, Coastal, PII Coastal, and the CFO joined the institution in March this year. So those positions have been filled. So we don't have a huge vacancy rate amongst the senior management positions. It's only those two that vacated recently. With regards to the fruitless and wasteful expenditure, the PFMA is very clear in terms of how fruitless and wasteful expenditure should be dealt with. There must be an investigation, and then subsequent to the investigation, the matter must be presented to the Financial Misconduct and Loss Control Committee, which is a committee that we have in the institution, and that's the committee that then makes a recommendation to the CEO, depending on the merits of the matter, whether to write off or to recover from the incumbent. And we do that diligently, and we do hold people account where we make them pay for whatever they have lost, especially on fruitless expenditure, because there's a tendency by people to say, I've lost my laptop. So if the investigation reveals that you were negligent in the manner in which you managed that or you handled your laptop, then we make people then pay for those laptops. I'm first going to deal with the questions that I have to deal with, and then I'm going to ask some of my colleagues to assist me to respond to others. We have done a calculation with regards to Mr. Horn's question regarding the calculations for the cost of the impeachment. We have a breakdown of all the calculations of the legal fees. As at the end of March, we had spent 30.1 million rands, But as we stand today, we had already spent 30.5 million rands, and that includes the legal fees themselves that were paid to the PP's legal counsel, which amounted to 31.6 million, travel costs 330,000, and the VIP protectors as well cost us 565,000 rands. And then the legal team as well, at some point we had to pay for them to make sure that the process goes ahead. We paid 348,000 for them. So all in all, we had spent 33.5 million as an institution on the impeachment only. Then the other question from, I think this one came from, I'm gonna ask my manager legal services to respond to the legal issues, but he'll respond after I've responded to all the other questions. The other question then was from about the funded posts. How many of the funded posts? We said we had 372. By the end of the financial year, we had 343 positions filled. And we fill the positions as people leave. However, because of the process that needs to be undertaken, it's not possible to fill a position within a week or even within a month, especially for senior management positions, because after you advertise, there's a time that is allocated for the people, for the position to run an advert. And then you still have to do the shortlisting, you have to do the interviews. Subsequent to the interviews, the recommended candidates are taken through a competency assessment. So that's why it takes up to 3 months in some instances to finalize the process, the recruitment process. But it's not possible to always have 100%, because over the years that I've been in corporate services, in HR, I've never seen a situation where you have 100 people, 100% of all the people, because as somebody joins the institution today, somebody either leaves or they retire, or unfortunately they pass away. So there's always that movement within the institution because people come and go from time to time. But the norm, the acceptable norm is that you need to try and maintain your vacancy rate below 10%. And we're able to maintain it at least at 7% throughout the years. And then, may I at this stage ask the, okay, Honorable Breitenbach, we seem to have lost some of your questions because we were disconnected for a while, but I see the acting public protector has sent me something. So if I can, whilst Ndili is responding to the other, my head of my legal services person is responding to the questions, then I can probably quickly pick up on the questions that we missed when we were disconnected from the system.
Thank you, that's fine.
Okay, it seems as if he stepped out a bit. I'm told that I missed a few questions. I think it was when we were disconnected. There was a question regarding the community-based organizations, whether we've made a presentation to people with disabilities. I must be honest, since I joined this institution, I cannot remember us making a presentation specifically to people with disabilities. But that's why now we engage in the CBOs, because the community-based organizations are the people who are supposed to help us as well, identify those people in communities so that we can reach out to those people, because we're mindful of the fact that that's a group of vulnerable people that we could be missing out in terms of service provision as the public protector. And in the current financial year, we've made a deliberate plan to make sure that we reach out to those people, because they are a critical stakeholder. And because of their vulnerability, they are people who are prone probably to abuse by even state institutions. So that's why we identified them as a key stakeholder that needs to be reached within this financial year. But previously, I cannot remember, over the last 2 years since I joined PPSA, I cannot remember an instant where we deliberately had a session with people with disabilities, but it is on the cards for this year because we have realize. That's why even when we deploy technology now, we know we deploy all sorts of technology, but we are mindful of the fact that we might not be reaching out to them because of their disability. They might not still be able to access our services. So we will make plans to make sure that we reach out to them. Yes, again, with regards to the process to recover the money from the public.
CEO, yes. you need to be more specific than that. The issue of disability has been with us for a very long time, and we don't expect institution of state at this late hour just to be giving us broad statements on how they are trying to reach out and recruit people with disability. There is a government policy that at least 2% of people living with disability should be recruited. I think by now you should have made concerted effort and we should be seeing your concrete plans of ensuring that there are people with disability within the organization.
Okay. Thank you, Chairperson. I fully agree with the Chairperson. With regards to recruitment itself, specifically, our HR now has been given instruction to go to talk to institutions like Disabled People of South Africa, DPSA, when we recruit, to make sure that we also tap into that. But there are other institutions that they said they're exploring, as well as the institutions of higher learning, because you find that there are people with disabilities who attend classes somewhere. So they are making efforts to reach out to those people as well as the SETAs. We had also, because some people go through learnerships with SETAs, people with disabilities go through those learnerships. So we're also approaching the SETAs then to make sure that the SETAs can help us identify these people with disabilities who we can probably approach, even not wait for them to apply, but who we approach to make sure that we it's a pity that we have been very cautious to advertise positions lately because we were just managing the risk of the budget cuts. But it seems as if we are not going to be getting any budget cuts as PPSA in this financial year. So which means as soon as we continue with the recruitment, then we will definitely intensify that. I was talking more on the other stakeholders, the community stakeholders that might want to access our services. There, I don't think we have actually made efforts in the past to reach out to the community, but we are in the process of producing the brochures that we have in Braille to enable those who can read to read in Braille. So it's a process that we had started and we wanted, that's why I said there are plans in the current financial year to reach out to those people that we believe are vulnerable and we are not reaching out to. And the disability sector is one of those people that we will be reaching out to. And as I was saying, with regards to the recovery of the money for the accommodation of the public protector, we have started the process. We have done the calculations and everything. But however, the irregular and fruitless and wasteful expenditure framework that is applicable, issued by the National Treasury, only applies to employees. It doesn't apply to executive authority. So that's why we decided that maybe we should do all the calculations of everything that probably needs to be recovered and then make a full presentation to the National Treasury so that we can get guidance. Because what we have now only applies to executive authorities. It applies to employees and not executive authority. That's why we felt the Treasury should be able to guide us. But in line with the principle of recovering from anybody who commits fruitless expenditure, Treasury will guide us, and I'm sure they will give us the go-ahead to recover, and then we will then start the process of recovering.
But sorry, CEO, when did you realize or when did your system start picking up that there is an irregular expenditure in that area? Because I think it's about 2.1 million. I mean, if you have a robust systems, they should not start to work when a person is out. So when did you start realizing that that accommodation issue is irregular?
The information is there, Chairperson. The information on the accommodation is there. But we didn't want to approach Treasury in piecemeal because besides the accommodation, the information, the expenditure on accommodation, we want to check whether there isn't any other. Remember, there were court orders, personal costs that were given to the PP. And at some point, we got a sense that some could have been paid by the Public Protector South Africa. So we want to do all the calculations of every money that we could have paid, that we shouldn't have paid as an institution from 2016 to date, to make sure that when we approach Treasury, we approach Treasury holistically, because we don't want to go to Treasury in piecemeal. The accommodation is clear, it's there because we paid Public Works directly. So that information is there. But with regards to the legal fees, then we have to go through all the legal invoices and pick up on those that we shouldn't have paid as the Public Protector. A case in point is a matter of the Speaker, is the Public Protector versus the DA, the Democratic Alliance, which is a defamation of character matter. We understand that previously the institution paid for that, and we believe we shouldn't have paid for that as an institution, because the institution was not the one that was defamed, but it was an individual. And we believe that we shouldn't have paid because the matter happened before the Public Protector assumed office. So it was not supposed to be paid. So it's all those, and it's a question of going through all the invoices from 2016 now to check which ones were we not supposed to pay. And then when we write to Treasury, we want to say, this is the total amount that needs to be recovered. Tell us, guide us in terms of how then do we recover all this money from the individual.
With respect to the accommodation, I think it was 2.1 million. Yes. Did the institution advise the Public Protector that this is not in accordance with the prescripts of the law?
This is a matter that started in I think she moved into that house in 2018, 19. So at that stage, we found something subsequent to the former PP being suspended. We found something that says there was an attempt by the Chief of Staff, the then Chief of Staff, to advise that pointed that the state cannot pay for this. And subsequently, we also then found a letter that was written by the then Minister of Public Works, the letter that said to her she needs to sign a stop order towards the payment of rental. But it's a pity that that information doesn't seem to have been given to the institution. It was kept somewhere. It only came out after we appointed the senior manager legal services, who started then digging and talking to people, and then all this information came forward. So that's why it's only now then we're doing the calculations and everything, because we believe she was advised that this cannot be paid for by the state. However, the advice was not yielded.
And then with respect to the legal costs, the defamation case and the other costs, was she advised that the PPSA is not legally bound to pay?
That's why we're still searching, because we haven't found any information so far. That's why we're going through all the legal records to determine if even the person who appointed the legal representation, probably in the memo, could have mentioned. We're still trying to find that. And so far, we haven't found anything to that effect, but we're still looking. That's why we say probably we shouldn't rush into approaching Treasury to say this is the figure, because what if we miss something else? We just want to make the full calculations, and we believe we are closer to getting to the total amount, and we should be able to approach the National Treasury within the next week or two with regards to that.
Okay, thanks.
Thank you. My legal person has gone out. Maybe we should rather give the public protector, the acting public protector, to respond to some of the matters that I could have missed, and then we'll come back to the legal.
Thank you. Thank you, Chairperson. Thank you, CEO. Okay, Chairperson, let me start with the lighter matters, just to clarify. I think CEO has forgotten. The former public protector was very well advised of the issue of the home that she was living in. Hence, at some stage, she had to move to a less costly place whilst we were still verifying with SAPS the circumstances under which she was living at that accommodation, which was paid for by the office. And as we were investigating the matter, the documentations were not properly forthcoming, considering that the current CEO was not the CEO at the time, and basically the executives who are from CEO, CFO, were not the executives at the time when this incident took place, but also from the part of the SAPS. The current commissioner was not the commissioner, the head of SAPS at the time when these incidences took place. But we then subsequently received the information, and SAPS having said that there was no authorization from their side in the form of a security report. It is then that the institution then requested the PP to vacate the housing. So it was brought to her attention. The legal costs regarding cases that the PPSA was not supposed to have paid for. This issue was also brought to the attention of the public protector. Hence, we discontinued payment of these cases immediately after her suspension. This also involves some of the litigation that took place in the Western Cape. So when we did that, we actually brought that to her attention. Now, the reason why we have not properly finalized these, there has been consultation with National Treasury, and the CEO says the issue of her not being an employee but an executive authority and there not being precedence in that respect has been a bit of a hassle, but also our resources at legal services to then properly and timeously or speedily rather do these calculations has really hindered us. So we are busy with that. Advocate van der Merwe is busy with that, but unfortunately he has been taken by a little bit of ill health. Further, on the figures that the CEO gave on the on the fees for the Section 194 inquiry, there is a 900,000 rands that we have still not paid, and that is the amount that Advocate van der Merwe is busy verifying. And unfortunately, we are verifying it on our own, Honorable Chair, so it is taking a bit of time, but we have not effected payment in this regard until we have satisfied ourselves that indeed this money is payable. And if I may just remind honorable members that this is the amount, part of it, which involves the withdrawal of the attorneys, other attorneys taking over, others withdrawing again, and others taking over. So those who've withdrawn have produced invoices ranging from 500,000 and so forth. And our issue is that the result of the work that they claim that they have done is what they cannot prove. They've read the records and then what? So are we then liable for reading of records that really have got no output? So that is really the issue that we are dealing with. Regarding the issue of the gratuity, Honorable Juan, at no stage has PPSA even made an attempt to try and say that amount, we will consider paying that amount, or whether that amount is payable or not. The determination for the public protector and the deputy public protector is not done by the institution, is done by processes outside of the institution. So what the institution has done in this respect is really to approach Parliament. The latest report or communication we received from their legal services is that they were in a process of procuring a senior counsel to give them a legal opinion. And this was also communicated by Parliament to the media. Now, the challenge of PPSA obtaining a legal opinion in respect of the function of the determination that is not the function of the PPSA is that the legal opinion might say whether the money is payable or not, but it would not say it's that for PPSA to do, but it would say it is for a particular body to do, and that is the body that is really responsible for the determination of the terms and conditions of the public protector. So therefore, that is where that issue is at this stage, that Parliament is interacting with it, and they had said they are procuring, or in the process of procuring, a senior counsel for a legal opinion. Now, Honourable Horn, on the inaccuracies in the report, you know, this is really, it was a really very shocking experience to us. I really want to assure honourable members that monthly we interact with our reports, with our statistics from both corporate services and core business. Quarterly, there is a leadership meeting where EXCO actually reports to me on the particular performances of the institutions, and we've got reports and all. But what is very clear that happened here, which we are also stating in our reasons for the revised report, is that the final report after the quality assurance, which I too was sitting on, it is clear that that report was tampered with. And by the time it was done, we had all satisfied ourselves, including me, because I was sitting in that final quality assurance, and that is before the quality assurance that EXCO had undertaken in respect of this particular issue. And at that stage, we also state that there was an issue of the signatures, where the said former employee had requested my signature and the CEO's signature in order to append to the report. For security reasons, we refused to give her the signatures and said it's unprecedented in the institution, to which indeed evidently she didn't take kindly. So when the report was then sent and the signatures were appended, we were satisfied that we had just come out of a quality assurance. We had interacted and read this report. Never in our wildest of dreams did we ever think that a report would be tampered with at that particular stage. But Honourable Horn and Honourable Breitenbach, we really now, one of the things that we've done is a calendar that at least gives us even a week or 2 weeks before for us to finalize quality assurance, and then thereafter be able to have individual checking before each and every one signs, which is really something that we could not have foreseen, that somebody would tamper at that stage. But also what we are doing, we are filling the position of the senior manager strategy very soon.